Summary of TCC Judgment 112, Champagne 13, 2023. Case on the penalty for selling Category 1 narcotics. High notes, as the punishment stipulated in Article 4, Paragraph 1, first sentence of the Narcotics Hazard Prevention Act is either a death sentence or life imprisonment. The defendants are still subject to disproportionately severe punishment, even after applying Article 59 of the Criminal Code for mitigating factors in their respective cases. Consequently, the provision restricts the defendant's personal freedom in a way that violates the principle of proportionality in sentencing, the principle that the punishment should fit the crime, and the principle of proportionality, rendering the provision partly unconstitutional. The decision in J1 Interpretation number 476 is thus altered within the scope of this judgment. Background note: Article 4, Paragraph 1, first sentence of the Narcotics Hazard Prevention Act stipulates that offenders of manufacturing, transporting, or selling Category 1 narcotics are subject to a death sentence or life imprisonment. Petitioners 1 to 3 are judges from Taiwan High Court, Tainan Branch Court, Taiwan High Court, and Taiwan Jianghua District Court who were hearing Category 1 narcotics cases hearing. Petitioners 4 to 8 are defendants of Category 1 narcotics cases. They are either first-time offenders, subordinates of the primary offenders, or involved in relatively petty drug dealing in terms of the amount of drugs or the monetary amount concerned. The petitioners argue that Article 4, Paragraph 1, first sentence of the Narcotics Hazard Prevention Act, hereinafter NHPA, prescribes the death penalty or life imprisonment for dealing Category 1 narcotics without distinguishing the severity and the mitigating factors of individual cases. The petitioners argue that the disputed provision violates the principle of proportionality in sentencing. The disputed provision's severity was once addressed in J1 Interpretation number 476 in 1999, in which the TCC ruled proportionate and constitutional. The petitioners also argue that J1 Interpretation number 476 should be revised. The petitioners filed for constitutional review respectively, and their cases were consolidated. Summary of judgment holding. Article 4, Paragraph 1, first sentence of the NHPA stipulates that offenders of manufacturing, transporting, or selling Category 1 narcotics are subject to a death sentence or life imprisonment. The legislators drafted the provision with life imprisonment as the minimum statutory penalty to prevent hazards brought by narcotics, although the legislators had their policy consideration for cases with petty circumstances and clearly forgivable situations in terms of the patent of selling, amount, and the price of the narcotics involved, and whether there were no other crime committed. The punishment could be disproportionate to the culpability, even if the sentences were reduced under Article 59 of the Criminal Code. Within this scope, the disputed provision has imposed a constraint on the people's personal freedom protected by Article 8 of the Constitution in a manner which does not conform to the constitutional principle of proportionality in sentencing, thus violating the principle of proportionality under Article 23 of the Constitution. The competent authority should amend the provision in accordance with this judgment within a 2-year grace period from the date of this judgment. Second, from the date of announcement of this judgment until the provision is amended, courts hearing Category 1 narcotics cases with the above-mentioned petty circumstances, besides applying Article 59 of the Criminal Code, may further have their sentences in accordance with this judgment. 3. In addition, considering that the circumstances and the harms of Category 1 narcotics selling cases differ drastically, applying the disputed provision and sentencing them all to the punishment, no less than life imprisonment, could be overly rigid. The competent authority should review the statutory penalty of the disputed provision and add option other than life imprisonment and the death penalty, and all stipulated respective penalty to other cases that involve different amounts and the frequency of selling narcotic category 1 narcotics. Fourth, the rest of a petitioner's act's complaint should be dismissed. Reasoning. 1. The punishment that the state imposes on the wrongdoers should be fitting to their crime. If one's punishment exceeds the amount that one should have borne for one's crime, it constitutes a violation of the principle of proportionality in sentencing, the principle that the punishment should fit the crime, consequently violating the principle of proportionality under Article 23 and the protection of personal freedom under Article 8 of the Constitution. 2. The disputed provision punishes the selling of Category 1 narcotics with a statutory penalty of no less than life imprisonment. This stipulation must have been for the reason that the Category 1 narcotics are most dreadful in terms of their abuse and dependence potential and their hazard toward society. It must have also been for the reason that the action of selling narcotics lies in the roots of drug supply and was deemed of grave hazard and thus need to be heavily punished. From this sense, this provision does not only serve to prevent drug buyers from being harmed, but further emphasizes the protection of all citizens' health and the social order and the national security. The provision can be considered to involve especially important public interest, thus falling under the legislature's policy consideration. 3. However, Category 1 narcotics selling cases vary drastically in terms of their extremely diverse circumstances. From the perspective of selling process, the pattern could vary in terms of the organization, the scale and the amount, the prices and the frequency, and the person involved, users dealing with each other, people who simply deliver narcotics for the dealers, etc. The activities of selling narcotics present a spectrum of circumstances of the crime that clearly differ in their severity and the degree of harm to a society. The disputed provision stipulated that the minimum statutory penalty for selling Category 1 narcotics is life imprisonment based on its legislative purpose of preventing drug hazards. Yet the provision did not provide a sentencing model level with the cases of a different degree of severity, nor did it provide a mitigating mechanism for minor violation. For cases with petty circumstances or clearly forgivable situation, applying the disputed provision could be excessive and not conform to the principle of proportionality in sentencing, even if their sentences were reduced under Article 59 of the Criminal Code. Within this scope, the restriction the disputed provision posed toward personal freedom violated the principle of proportionality in sentencing and the principle of proportionality. The decision in JY Interpretation number 476 should be altered within this scope. The competent authority should amend the provision in accordance with this judgment within a 2-year grace period from the day of this judgment. 4. The NHPA set up different statutory penalties for possessing and transferring based on the amount involved. It should be worth